Number 1, 4405, a post-trial motion must be made within 15 days after decision, verdict, or discharge of the jury. And the note here is the court shall have no power to grant relief after appeal from a final judgment. So that's just a note. 2, 4402, at any time during trial, court on motion of any party may order a continuance or a new trial in interest of justice or on terms as may be just. 4403, a motion seeking to have a court confirm or reject the verdict of an advisory jury or the report of a referee to report, because there's 3 kinds of referees, this one's talking about a referee to report, shall be made within 15 days after a verdict or filing of the report and prior to further trial in the action. 5002, if a plaintiff obtains a money judgment which includes interest, the amount of interest is computed by the clerk. Okay, number 5 is a challengeable question, and I put that in the answer key because OCA is probably going to have at least 1 or 2 questions on this test that are challengeable, and don't do what I did on the last test, which is stare at them in anguish, wasting precious time, wondering why there's no right answer there. Just move on. Because this question had no right answer. That may very well happen. Just pick something and move on. Because obviously the jewelry cap is $1,000 on everything but a wedding ring.
Want you to study that one. You got it? Especially noting amounts for real property in the different counties.
And know that basically all the retirement, Social Security, pensions, anything with a 401k, it's all exempt from satisfaction. Any non-party may serve a summons false. They must be over 18. A court may relieve a party from an adverse judgment on the ground of excusable default. That's false because it has to be within 1 year. Applications for default judgments must be made to the court. False because under certain circumstances may be made to the clerk. 9, a motion for summary judgment may be made at the commencement of any action. I didn't know the answer to this one.
After it's joined, Mary.
It's okay, so it's after issue is joined. So thank you.
30 days before or
Correct.
120 days.
Okay. So it's not less than 30 after issue is joined, or not less than 120 if it's not. Okay, judgment roll must be prepared by the prevailing party or his attorney. Not true, that's false, because or clerk, whether or not that actually happens, that's what it says in the book. True, a plaintiff and defendant may stipulate to submit a case to the court under a simplified procedure as set forth in the CPLR. Remember, that's an action without pleadings or an action before a summons even was filed. True, a motion for summary judgment must be denied if there's any triable issue of fact. The essence of a summary judgment motion is that there is no triable issue of fact. Release is official evidence that a debt has been paid and satisfied. That's false, it's a satisfaction. 14, any real property up to $50,000 in value is exempt from a civil judgment. This is false, the amounts are wrong, and it must be a homestead or a lot of land used as a burying ground. So that's the only types of real property exempt. 5001, the date from which interest is to be computed shall be specified in the verdict, decision, or report. 5004, the rate of interest shall be 9% per annum, 9% per annum. 5011, the determination of the rights of the in a special proceeding, it's a judgment. 5015, this is a repeat of another question. It's 1 year for excusable default after service of the judgment or order with written notice of its entry. 5016, in order to enter a judgment, the clerk must sign and file the judgment. 5017, and they're all correct, which if any are true about a judgment roll, may be prepared by the prevailing party's attorney, may be prepared by the clerk, must contain pleadings. If an appeal was taken, must contain determination and opinion of each appellate court. If a trial was had, it shall contain the verdict or decision. Except for income executions for spousal support or child support in general, what percentage of a debtor's income is exempt from levy to pay a judgment? The answer is D, 90%. This also does not apply when the state is the creditor. 5241. For purpose of a support order, a default is defined as the failure of a debtor to remit to a creditor 3 payments. 5241, where an execution has been issued by the support collection unit, the debtor may assert a mistake of fact and shall have an opportunity to make a submission in support of the objection within 15 days from service of a copy thereof. Thereafter, the agency shall determine the merits of the objection and shall notify the debtor of its determination within 45 days after notice to the debtor. Okay, 5241. In general, if a debtor is supporting a spouse or dependent child other than the creditor in whose favor a support order has been issued, the maximum amount of deductions to be withheld shall not exceed 50% of his or her earnings. And then there's 2 time rules in that. There's a 14 and a 7. Just maybe look at what they are. 25 through 27, I'm skipping those. They were on previous exams. CPLR 3402, a party may file a note of issue at any time after issue is first joined or 40 days after service of the summons has been completed, irrespective of joinder of issue. 5501. In general, the Court of Appeals reviews questions of law, and the only time they would review a question of fact is if the appellate division found new facts. 5514. If an attorney for an aggrieved party dies, is removed or suspended, or becomes physically or mentally incapacitated or otherwise disabled before the expiration of the time limited for taking an appeal, and I would underline that part of the question, before the time expires, or for moving for permission to appeal without having done so, such appeal may be served within 60 days from the date of death, removal, or suspension or commencement of such incapacity or disability. This is different than the other one, the other section that talks about an attorney dying or getting suspended, because in that one, before the case is over, there has to be notice to appoint another attorney served. Whereas this one is just saying whether or not you found out your lawyer had died, it's measured from the date of death. 5515, if a losing party decides to appeal, he must file a notice of appeal in the office where the judgment or order of the court of original instance is entered. And then you should probably make a list. There's a couple of things that the notice has to designate. 5513 and 5516, a motion for leave to appeal must be made within 30 days and shall be noticed to be heard at least 8 days and not more than 15 days after notice of motion is served. 5513, in general, if a party is served with a notice of appeal, he must serve his notice of cross appeal within 10 days after service. 5515, whenever an appeal is taken to the Court of Appeals, a copy of the notice of appeal shall be sent forthwith to the clerk of the Court of Appeals by the clerk's office where the notice of appeal is required to be filed. 5518, the appellate division may grant, modify, or limit a preliminary injunction or TRO pending an appeal or determination of a motion for permission to appeal in any case specified in 6301. And the answer is D, the appellate division only. Okay, 36, I got tricked on that one. Mary had to help me understand it. But basically, 1 is correct. It may be granted ex parte. 2 is incorrect.
Well, it's not or.
Because it's not or. Okay, so it's immediate and irreparable injury, loss, or damage will result unless defendant is restrained before a hearing can be had.
Everybody should remember it's and that's for TRO.
So you need both. You need immediate and irreparable. Unless the court orders otherwise, a TRO, together with the papers upon which it is based and a notice of hearing for the preliminary injunction, shall be personally served in the same manner as a summons. And prior to the granting of a TRO, the court may require the plaintiff to give an undertaking. They're all correct, except for 2, because it says or instead of and. So it's a study question if you change or in huge letters, which I'm going to do right now, and write and.
Some people change or to and on their paper and change the answer then to all to
Which
make
I'm
it a
going to
study
do
question.
because, yeah.
But it's and. It's very important to remember and.
This is another question I had a lot of trouble with. Do you want to just go over this one? Because I still don't really understand it.
The problem with 37 is the answer was kind of messed up.
It cut
Okay,
off the real
so
number
let's-
2, so it
Something is missing from when it was typed. not this time, but which, if any, of the following are true concerning modifying or vacating a preliminary injunction? Before we go, I better look up for a minute. Everyone has to remember, what's the biggest difference between a TRO and a preliminary injunction?
Notice.
A TRO can be made without notice. A preliminary injunction can never be granted without notice. Okay? They're very different. A TRO is for immediate and irreparable injury.
So what you want to do on this question is write in a number 2 and write it may be granted at any time.
That should have been the number 2. What's listed as 2 should have been 3. So 1 is wrong because it says without notice. And you can never move to modify a preliminary injunction without notice because it was only granted after notice.
So then 2 is supposed to be it may be granted at any time, and that would be correct. So you can put a little check next to that. Then the one that says 2 is supposed to be number 3.
And that's correct. The court may require an undertaking.
And then 3, the one that says 3 should actually be number 4, and that is incorrect because that one is talking about a TRO, right? No, what is that talking about?
Look at this section.
I don't remember. This is why you have to do
Open
this
the
one.
book to 6314. Everybody open your book to 6314 for a minute.
6314.
If you look at 6314, you will see that there's nothing about
It's about a TRO.
this belongs to a TRO. You look at 4 would be correct for a TRO.
It's in the same paragraph, but it's talking about it without notice.
Okay? The whole purpose of these questions is to get in your mind the differences between a preliminary injunction and a TRO. So you have a list for TRO in your mind and a list for preliminary injunction in your mind. This
And a list for
question
order of
tends to be
attachment.
popular for principals more than associates, but it is a popular area.
38. Please change the section to say 6312. You must show that there is a cause of action, and then you need either 2 or 3 to be true. So that's why the answer is 1 and either 2 or 3, and the answer is C.
Look at the language in the 2 places. The first says that the defendant threatens or about to do or is doing or something in violation of the plaintiff's rights, or that the defendant is entitled to a judgment restraining. First is what? Let's go back again. That the defendant threatens or is about to do or is doing an act of tending to render the judgment ineffective. Okay, so the first one says what the defendant is doing would tend to render the judgment ineffective. So give a preliminary injunction that says you, defendant, may not ship the painting to Russia. That would render the judgment ineffective. The second one says that he's doing an act that would produce injury to the plaintiff.
1, that there is a cause of action, and either the defendant threatens or is about to do an act in violation of the plaintiff's rights respecting the subject of the action and tending to render the judgment ineffectual, or he's still got to show that there's a cause of action and that he's demanded and would be entitled to a judgment restraining defendant from commission or continuance of an act which, if committed or continued during pendency of the action, would produce injury to the plaintiff. 4 apparently was on the test. Foreign judgment means any judgment, decree, or order of a court of the United States or any other court which is entitled to full faith and credit except one obtained by default in appearance or a confession of judgment. 5402. A copy of any foreign judgment authenticated in accordance with an act of Congress or the statutes of the state may be filed within 90 days of the date of authentication in the office of any county clerk in the state. 5403. Within 30 days after filing of the judgment creditor shall mail notice of the foreign judgment to the debtor at his last known address. 5205. This is basically except for child support or alimony or maintenance. Certain payments payable to members of the U.S. Armed Forces are exempt from application to satisfaction of unpaid judgments, but the protected persons do not include commissioned officers. It's only the other 3. It's privates, non-commissioned officers, and musicians. Okay, the next one is true. I'm not going to read that again. 5224. Just remember, information subpoena. Answers shall be returned. They have to be in writing with their original questions within 7 days after receipt. Okay, and there's a lot of rules about information subpoenas, what they have to say on them. If you want to take the time to read that section, You're gonna read a lot of information about what they have to say. You basically can't take an information subpoena, serve it to 55 banks, and hope that the judgment debtor has an account in one of them. You can't do that. 5015, true. The clerk of the court may vacate a default judgment pursuant to 3215 upon the filing with him of a stipulation of consent to such vacatur by the parties personally or by their attorneys. This is a study question, I believe. 5015 sub A, the court which rendered a judgment or order may relieve a party from it upon such terms as may be just on the first time he ever got a phone call, it's in class. On motion of any interested person within such notices as the court may direct upon the grounds of, and I'll try to abbreviate these, excusable default within 1 year, newly discovered evidence which could not have been discovered, fraud, misrepresentation, or other misconduct of an adverse party, or lack of jurisdiction to render judgment or order, or 5, reversal, modification, or vacatur of a prior judgment or order upon which it is based. Pretty much, if you see fraud and they're talking about vacating something, usually you're going to be able to vacate something. If you can prove the other party did something fraudulent and defrauded the court or the arbitrator or the judge or something, they don't like that. So you may be more likely to guess right if you guess yes, that can be vacated if you see the word fraud in there. 5015, that is a study question. That's the Judge Thompson decision. I can't read that whole thing. Just please read it. You should be able to recognize that on the test if you read it a couple of times. 5222, a restraining order may not be served upon the judgment debtor's employer where the property ought to be restrained consists of wages or salary due or to become due to the debtor or obligor. And why is that? Because what do we serve on the employer? Income execution. Okay, not a restraining notice. True, a judgment debtor's or obligor served with the restraining notice is forbidden to make or suffer any sale, assignment, or interference or transfer with any property in which he has an interest, except upon direction of the sheriff or pursuant to court order until judgment is satisfied.
It's direction of the sheriff, not just the court order, it's also the sheriff.
5222, leave of court is required to serve more than one restraining notice upon the same person with respect to a judgment or order.